An I601A waiver gives people who entered the U.S. without inspection, meaning entered without seeing a Customs and Border Patrol agent who looks at their passport and visa. Those who don't have that have an option to still obtain a green card or family-based immigrant visa by filing something called a 601A waiver. Now, all this waiver cures is unlawful entry and presence in the United States. Doesn't cure every ground of inadmissibility that might apply to someone. So what happens when you file this waiver is you file it here stateside with USCIS once an I-130 is approved, and USCIS determines, is there really going to be hardship to this U.S. citizen petitioner or lawful permanent resident petitioner, spouse or parent, if the person who entered unlawfully is not provided the immigrant visa. And more or less, you have to show hardship from a multitude of perspectives: financial, emotional, psychological, medical. Every type of hardship you can imagine, you need to compile and have the attorney, if you hire one, which is advisable because these are complicated applications. You have to compile these and to present a hardship-based argument to USCIS. And they look at things cumulatively, so you want to make sure that you touch on each specific hardship in a brief. And what happens is, ultimately, if they believe that there is extreme hardship to the U.S. citizen, they will issue the waiver. And then this enables that individual to exit the United States, have an immigrant visa interview overseas where their citizenship is, and if granted, they're going to return to the United States and be mailed a green card. So it solves an issue that otherwise is not solvable by remaining in the United States, because you can't trigger the 3 or 10-year bar of unlawful presence without departing the United States. So this gives people an option to know that they're going to be forgiven for that specific issue before they even leave.